let's jump right into the standard of care breaches that are alleged here. Ian, essentially this is count two, paragraph 115 of the complaint, some 52 breaches here. Um, and I did note I did spend most of my time last night reading through the two plaintiffs' plaintiffs' experts' depths, Derange and Dr. Caldwell. And, it appears that, their alleged breaches here are, you've got these red flags, if you will, um, maternal obesity, um, you know, at least potentially large baby, although I think the baby when it was born wasn't particularly giant. Um, and those ought to have been warning flags, along with the some delays in the progression of labor. And the bottom line is Caldwell opines he would have called a C-section at some point earlier, but at latest at the point when suction was applied. Now, when suctions applied were minutes from birth. And I think the argument there is, well, gee, doc, it would have taken longer to wheel her in and do a C-section than it wound up taking to do the suction. But in making the decision to proceed with vaginal delivery and traction applied by the suction, that the doc in effect uh, caused the uh, well, it didn't anticipate the shoulder dystocia, which, appears to be one issue, that perhaps could have been addressed differently, but perhaps more importantly, that the traction caused the, boy, I'm slipping up on my medical terms here, is it the brachial plexus injury, and those are the traumas that occurred along with some hypoxia, though, everyone seems to agree that we're not talking about hours of hypoxia here, but, some hypoxia that was indicated by the monitor strips, particularly during the last portion of the delivery, but, perhaps earlier than that as well. And ergo, those are essentially the claims that we're going to go forward with. And I mean, I noted that I think one of the docs said, "Well, this is fairly straightforward. I can explain it to you," and sort of, belies the fact that we got 52 separate alleged breaches here. So, what is your position today? I mean, can I simplify it like that and allow I think you've allowed five of the subsections to proceed, although I think you'd like me to narrow it even more than what I've stated, Mr. Anderson.
Only with respect to the hypoxia assumption there, Your Honor, because both Dr. Cardwell and Dr. Donraj indicated that there was no issue with oxygenation, no issue with the strips that required, um, emergent C-sections at any point. Their opinion was instead of offering the vacuum at 12:45 should have offered a C-section by 12:45. Of course, Dr. Cardwell said, I would have no problem if you did it earlier, but they both are consistent that the standard of care was not breached until the defendant providers offered a vacuum rather than the C-section at 12:45. And our position is simply that given that is the opinion on the breach of the standard of care, it is implausible that any of the earlier quote unquote events would have, uh, there's no possible way to establish a causal nexus between any alleged breach in the standard of care earlier than 12:45 and any alleged brain injury. I mean, obviously, we'll get to the other motion here later. There's no evidence that this child ever suffered a brain injury, to be frank. But even if we assume that there was, we can't, based on their opinion that the breach of the standard of care occurred at 12:45 a.m., 4 minutes before her birth. They both said that it takes at least 5 minutes to have any sort of worrisome hypoxia issues, like if you can't resolve the shoulder dystocia within 5 minutes, then it becomes problematic. This one was resolved within 30 seconds. So we have approximately 4 minutes or 4 minutes and 30 seconds between application of the vacuum and delivery of the baby. And a C-section at that point, would, as they admitted, would have taken 15 to 30 minutes. So if we're worried about hypoxia, they can't, we have no reason to have a C-section at 12:45 that would have taken longer, right? So either that's not a breach of the standard of care, or we can't establish a causal nexus to any brain injury as a result of hypoxia, because they're saying we should have taken a longer time to deliver this baby, and instead of doing it more expeditiously through use of the vacuum. Now they opine the vacuum caused the shoulder dystocia, but again, that's where we're running into a logical disconnect here. Like, you can't have it both ways. Either you shouldn't have applied the vacuum and avoided the shoulder dystocia, or you should have done a C-section much, much earlier, which is not what they opine. They opine the breach of the standard of care was 4 minutes before the birth. Therefore, there is no, all of these other claims regarding fetal distress and the fetal heart tracings and mom's oxygenation have nothing to do with the breach of the standard of care that they opined, which was offering the vacuum delivery instead of the C-section.
Well, I looked back and I think it's Crawford's testimony, and he said the latest there should have been a C-section would have been I mean, the could have been was at the time that the section was applied, but that or the vacuum was applied. However, I noted he left himself some room to say, I think essentially what he's saying is, these providers, given the history here, should have in effect been on a razor's edge about a C-section right from the outset with this patient, and perhaps should have called it even earlier. Now, I didn't. I did at least the Crawford testimony or the Caldwell testimony that I read. He did not talk about hypoxia based on the tracings earlier in the delivery, the course of the 12-hour delivery. But I had the impression that there were some decelerations, and, again, not perhaps for him to make the call with certainty that there was hypoxia, but rather, saying that these were warning signs that perhaps there was hypoxia. Is that what his testimony was?
No, Your Honor, and I'm pulling up in the brief on page 17 and in the deposition transcript, page 55. Caldwell said, quote, "Well, if you look retrospectively, the baby had good cord gases. I'm not saying the baby had HIE, and HIE stands for hypoxic ischemic encephalopathy. Quote, returning to the quote, I'm saying the baby sustained a brachial plexus injury and traumatic injuries, not from any hypoxia or asphyxia." So, I mean, it's very clear here that, and Dr. Donrush said there wasn't any problems or a lot. He said, quote, "There wasn't a lot of problems with the heart tracings along the way," end quote. He also said, quote, "There was no clinical indication of hypoxia or other brain damage at or near the time of delivery." So what they're saying is, because there's no indication that we need to rush this baby out because of hypoxia or asphyxia or terminal bradycardia or any other potential cause of a brain injury, you had time to offer a C-section and take an extra 15 or 30 minutes to perform the C-section rather than move forward with the vacuum more expeditiously. And that's precisely the point. Like, we can argue with the jury, or, we can argue with plaintiff's counsel in front of the jury about whether, we're liable for the shoulder dystocia and the 5 remaining standard of care allegations. However, that can't be the opinion of the standard of care experts while simultaneously saying, oh yeah, and this caused a brain injury because you didn't get the baby out in time, when they're sitting here saying you should have taken more time to get the baby out. And that's really all this is about, including with Dr. Crawford's motion, as not to argue that motion, but in her deposition, she had to backtrack from those standard of care opinions, even though she's not qualified to opine on the standard of care, and saying, no, that wouldn't be the standard of care to do the C-section at 12:45. It should have been much earlier, because she needs that to corroborate her opinions or establish the causal nexus there. And the opinions of plaintiff's standard of care experts, Doctors Donraj and Cardwell, cannot support or I guess back up Dr. Crawford's causation opinion. So that's really the pointed issue here, is all the things that happened before 12:45, based on their opinion, could not have caused harm to the baby or are not supported in the records as breaches. As you know, there's various categories and there's different reasons that we outline in our brief as to why these breaches are unsupported, either from the causation or evidentiary standpoint. As the court knows, in medical malpractice cases, plaintiffs have the burden to support a breach of the standard of care with expert testimony, as well as the causation component. So both of those components have to be there
And I
in
think,
order.
writ large, what you're saying is, Judge, we want a ruling from you that there simply is no sufficient evidence to proceed on a hypoxic brain injury, be it HIE or a, more, um, it'd have to be, of course, because it appears that there wasn't any, MRI type evidence of a brain injury, that, I think it's described as, micro trauma or something like that by, not excluding all micro trauma, because obviously the, brachial plexus injury and then the shoulder dystocia are in themselves traumatic, but rather there's no hypoxic brain injury or evidence for it supplied by these experts.
Yes, Your Honor, that's a big chunk of it. In addition to the significant amount of evidence to the contrary, refuting that, as we've outlined in our brief, um, as well as from the standpoint of just not permitting the jury to guess on this issue. Again, all all the evidence plaintiff has presented here is Dr. Crawford's causation testimony, which conflicts with the standard of care testimony. So we have a very disjointed and, I guess, for lack of a better word, broken causal chain here toward this hypoxic brain injury that's never been shown through any medical evidence. And we just don't want the jury to guess on this issue, considering this is one of the main issues in the case, and there's just simply no evidence for it.
And refresh me on the question of oxygen. When there was, my recollection is that there was oxygen administered. It just may not have been at the rate or consistency that plaintiff believes is required by the standard of care, or is oxygen a non-issue in your estimation?
In our estimation, it's a non-issue. Her oxygen saturation levels were always like 97, 98, 99%, showing that, as we showed in Exhibit A of our brief, the medical records, supplemental oxygen was supplied. I know plaintiff claims that it wasn't adequate or under the standard of care in the amended complaint, but in fact, Dr. Donraj specifically said she did not need Miss Evans did not need additional oxygen because there was no issue with the heart tracings or her oxygen saturations. I can find the exact quote, but
No, I recall that testimony as well, and that it did not seem like either of the experts believed, they didn't supply anything that looked to me like real convincing testimony that the oxygen supplementation, was um, missing. I think someone said initially it was missing and then corrected and said, "Oh, I see that they got it," and then said, "Well, but it was, it's not documented as perhaps the rate or the constancy," but didn't then link that to saying, "Okay, and ergo, that would have caused a hypoxic injury." In fact, as you've pointed out in your, I mean, it looks like Crawford essentially extends, excludes a hypoxic injury in his testimony. So, all right. Well, let me have Mr. Dibb weigh in. I mean, obviously, Mr. Dibb, if and I think I was, yeah, that's Cardwell's testimony here. Um, yeah, and I do, I noticed this just, in reading his testimony that, Cardwell says, hey, look at, you know what, a baby can be in a hypoxic condition for up to 60 minutes and not suffer a brain injury. And no one's saying there was a 60-minute stretch here where the baby may have been in a hypoxic condition. So it sounds like Cardwell, by implication, if not directly, rules out hypoxia. Is is that my correct ruling today, Mr. Dibb, or wrong?
Well, there's a lot to unpack here, Your Honor, and from listening to you questioning counsel, you've obviously spent a lot of time reading over the motions and the testimony, and thank you very much. But the thing that I am always curious about in these motions, particularly this motion, is the defendants are attempting to parse out the plaintiff expert's testimony and then give lawyer commentary on the testimony. But there is no defense medical expert to support any of the claims that a defendant asserts in either of the motions. There's no defense affidavit. There's no testimony whatsoever from any defense expert by affidavit or otherwise that supports any of the claims. So what we have is a lot of lawyer speak trying to comment on what the experts are trying to relate. Now, with respect, if I could just address the cesarean section issue, the plaintiff alleges that defendants prolonged the delivery and failed to timely perform the cesarean section. But we're not talking about just minutes before the delivery. Dr. Cardwell testified that Mrs. Evans had several risk factors that required consideration of cesarean section right from the beginning. She weighed over 300 pounds. She had gestational diabetes. It was a large baby on examination, first pregnancy, and a prolonged labor. And he testified that under these circumstances, collectively and some independently, precluded the attempt at a vacuum extraction. And he further testified that
I think it's pretty darn clear that, Cardwell is saying, I would have called a C-section earlier, at the latest when the vacuum extraction occurred, but maybe even before that. And ergo, I could have avoided the vacuum and subsequent trauma. But he's not very convincing. I mean, he appears to rule out hypoxia as one of the reasons.
Yes, Your Honor. Let me also add that Dr. Donraj also testified that operative vaginal delivery, as what was attempted here, was inappropriate, and they shouldn't have even attempted or proceeded with a vacuum delivery. So what defendants are arguing is that plaintiff's experts, and again, this is a lawyer arguing this. This is not a medical.
Oh, that's what we do, Mr. Dibb. We have to apply the law to the facts. So
right.
I don't fault lawyers for that kind of stock and trade, I guess.
I agree, but the point being is when we're talking about science and scientific issues and issues that should be addressed by experts, there are no defense experts to support the arguments that defense is advancing. They only criticize the last 4 minutes before birth, and that's wrong. The plaintiff's experts criticize the entire critical decision-making process leading up to the vacuum. And this argument, the last possible moment testimony argument, does not erase the broader criticism that cesarean section should have been considered from the outset. So this latest possible time, they're trying to turn this argument of latest possible time into only possible time. And that's not what the expert testimony says. Now, with respect to the fetal heart tracings and the fetal distress, that suggesting and supporting the argument of hypoxia, plaintiff alleges that the defendants didn't properly monitor the fetal status and failed to timely intervene in the presence of what were concerning tracings. Dr. Cardwell, for example, testified that fetal tachycardia, the minimal variability, the repetitive variable decelerations, the prolonged decelerations, and absent variability were all indicia of a baby in distress who was under stress and was in fact suffering hypoxic ischemic encephalopathy. He testified that the fetal tachycardia with the minimal variability and the decelerations did in fact constitute a non-reassuring tracing, and that should have been
If I
acted
can
on.
just pause you, Mr. Dibb, though, I
Yes,
didn't
Your Honor.
read that until he was, commenting on those last, writ large, 30 minutes prior to delivery. But before that, he didn't fault those tracings, or he may have faulted the lack of tracings, or perhaps, but I mean, I think that that what he's saying there is, and he does say, prior to that, retrospectively, the baby had good cord gases, indicating that, even though there may have been warning signs, I guess, and those, maybe evidence that he should have called the C-section earlier, he doesn't seem to, be very concerned about the extended or a longer bout of hypoxia until that last 30 minutes, or am I missing something?
Well, I think what he said was that, as I was pointing out, that throughout the labor course, the tracings did identify a baby who was under stress and in fact in distress. And that these, and I think Dr. Crawford buttresses this this opinion, that these findings of minimal variability, the repetitive variable decelerations, the prolonged decelerations, the absent variability, that these are all signs of hypoxia. And I think Dr. Crawford did a nice job explaining what those findings signify.
Okay. No, I think I understand the argument, and I think, right, and I'm not only from doing these cases, but being present for the birth of 9 of my 10 kids anyways, I've watched those heart tracings like a hawk, and I know they are variable and that they can be warning signs. However, my impression is that there has to be some extended period of hypoxia. I've also noted it doesn't have to be very long, and then the docs are really, concerned, about the tracings, and then they jump right on it and consider the C-section. But my impression is that this case didn't, rise to that level until these last 30 minutes per both experts. I mean, Derange does say, well, I had some worrisome tracings along the way, and I think that's probably true, but he doesn't say those worrisome tracings indicated prolonged hypoxia and thus the hypoxic brain injury. So, I mean, I think that's what at least I see Mr. Anderson as driving at.
That's that. So you can see where a question of fact has been established. I think Dr. Crawford did a very nice job explaining that that hypoxia and respiratory distress all equate to the neurologic injury and the developmental delay and cerebral palsy and cognitive impairment that this child
So
suffered.
you're talking about Crawford now.
Right, but and what I'm yes, and I
Yeah.
forgive
no,
me.
and I do
didn't
want to
mean
get to
cross
her.
over. I didn't mean to cross
yeah.
over. But in addressing your question about the hypoxia, but I'm sorry.
Yeah, no, that's okay. I didn't want to get Crawford and Caldwell. They both start with a C. I don't want to get them crossed in my head. I've learned I'm getting a limited capacity to sort these things. So
So where were you in the 10th delivery? By the way, you were there for
we
9.
adopted our 10th.
Oh,
So
okay.
I was not present.
I'm just
Like your experts, I did a record review on that one. So.
I'm just kidding.
No.
Thank
yeah, no, yeah, no, I had my wife born said baby, I would, of course, moved heaven and earth to be there like I did with the previous 9. So,
Yes, sir.
all right, Mr. Anderson, I'll give you the final word before I make a ruling on the partial motion for summary.
Sure. Thank you, Your Honor. Just a couple things I wanted to address from the questioning of Mr. Dibb. First, with respect to the lack of a defense expert affidavit, I mean, we've disclosed numerous defense experts. We have plenty of expert support. However, number one, plaintiff has the burden of proof. This isn't a battle of experts issue. We're claiming that the unambiguous testimony of
Their expert testimony
right.
standing alone is insufficient.
Exactly. And then secondly, with respect to that, the last implication that there's a question of fact here, there's no question of fact as to anything in our motion. We are simply going by the expert's testimony and whether, as a matter of law, there's sufficient evidence to support these opinions. And number two, whether the standard of the opinions regarding a breach of the standard of care tie correctly to the causation opinions without changing them, as I alluded to earlier with Dr. Crawford's standard of care testimony, without crossing over again. Otherwise, I think that's all I have, other than what we've talked about before and what's in our brief.
Okay, all right. Well, as I said, this is a C10 motion before the court, arguing, of course, under Michigan law that plaintiff does not have, and of course, in C10 motions, I have to view the facts in light most favorable to plaintiff, and that they do not have sufficient evidence to place questions that could reasonably be decided by a jury without requiring the jury to unduly speculate or guess as to what happened in this particular case. And I will also say from the outset, this is a partial motion. It's not asking for a dismissal of the entirety of plaintiff's claims, but rather a narrowing, if you will, of what those claims are going to be as placed before the jury. And as defense counsel has briefed and argued today, one of the critical questions here is there sufficient evidence that a hypoxic injury occurred sufficient to cause brain damage as alleged by plaintiff in the complaint, and then secondarily argued by, to some extent anyways, Dr. Crawford, although as we're going to take up later, she doesn't only say that, that hypoxia was the only or main cause here. She says more broadly that it was a birth trauma. But we'll save that one for later and take up the issue of hypoxia as to this motion for summary disposition. And also, I will note writ large, of course, the method of, the Michigan medical malpractice statute does require, at the outset, plaintiff to submit a affidavit of merit that has to be, by its nature, quite specific and quite broad as to what sort of injuries might have occurred. And what I view defendant as is asking me to narrow those claims at this time. And I do think it's an appropriate function for summary disposition so as to narrow the issues that are presented to the jury. And I think that, based almost entirely on Dr. Caldwell's testimony in his deposition here, I don't think that a claim for a hypoxic brain injury can be sustained because Dr. Caldwell does say, and this is from his deposition, somewhere between page 45 and 54. He does give an answer. Well, if you look retrospectively, which is, of course, what we're all doing here, but particularly the doc's doing a review of the records, the baby had good cord gases. I'm not saying the baby had HIE, which is, of course, the most extreme form of brain injury caused by hypoxia. But I'm saying the baby sustained a brachial plexus injury and traumatic injuries, not from any hypoxia or asphyxia. And of course, I had to go back and review. Of course, hypoxia is a low oxygen situation, and that's why even Dr. Caldwell does say earlier, well, sometimes babies can endure up to 60 minutes of hypoxia in some situations and not suffer that type of permanent brain injury. And of course, it's asphyxia that ultimately, the concern is about that because there is no oxygen at all received by the brain in an asphyxia condition, then of course, just like any human suffering asphyxia, death is going to certainly follow within a short period of time. And that also can occur with hypoxia, but the fact of the matter is it requires a prolonged period of hypoxia, and certainly not most, but cases where there is that HIE, which I'm not going to try to guess at what those. I think it's hypoxic ischemic encephalopathy cases do involve a sufficient period of hypoxia to cause severe brain damage to the child and cerebral palsy and things of that nature after the child is born. And this doesn't appear to be that case. The doctor here identifies hypoxia, but not as a source of the injury, but rather as a warning sign that there should have been a C-section called earlier in the case. And he did testify very clearly that he would have called a C-section earlier, and that the standard of care required at the latest a C-section to be called when suction was applied. Now, the vacuum was applied in this case fairly short period of time before the baby was delivered, and defense counsel has ably pointed out, well, it would have taken longer at that point to do a C-section. Now, I don't think that excludes testimony by Crawford that he would have combined these warning signs that he observed: maternal history, weight, size of the baby, the slowness of the labor in general, and some instances of hypoxia, though, as I said, I don't think he ever cites those as causing the injury in this matter. So I will then grant dismissal. I'm going to have to go through these one at a time as to the counts that aren't supported factually at this point. So I'm in this is count 2, paragraph 115. And there are arguments here made about the records. However, I do think that the depth and extent of records review inherently is going to be a fact question in this case. There is record evidence that perhaps undue or insufficient consideration was given to mom's obesity and also to potential that is the baby being a larger than usual baby, based on all docs' agreement that even though they had ultrasound imagery, it's difficult to estimate the, of course, size of the baby accurately from that ultrasound imagery. And I believe Dr. Crawford again testified very ably that it's really the ratio of, I think he referred to it, he had some term that I wasn't familiar with, the size of the baby's head versus the radius of mom's hips is really what you need to look at there, which of course would not be necessarily entirely illuminated by the ultrasound, but might be more clear from a more detailed review of the records. So records review can remain as a fact issue, as can paragraph B, obstetrical history. Um, Regarding C, vaginal exams, I believe that Dr. Crawford backpedaled on that and did indicate that in retrospect, these were the uh, measures of cervical dilation were done regularly. So C can be dismissed at this point. Um, D is an ultrasound to measure fetal weight and growth. Anticipate that a C-section would be necessary. I believe that there was testimony and acknowledged by Dr. Crawford that an ultrasound was performed some distance of time prior to the delivery, that she was doing regular ultrasounds to monitor, the progression of the pregnancy. And I did not hear him say that there needed to be an ultrasound, closer to delivery than the one. So I will dismiss sub paragraph D at this time. Of course, E goes to the heart of this thing, and that is the failure to timely perform the C-section in face of a prolonged delivery. Now there is some question there about, what really is the definition, and even more importantly, what was the definition perhaps back when this was occurring of a prolonged delivery. I think there are ample fact questions there developed by Crawford that this was a prolonged delivery, and ergo, the standard of care would have required a C-section at some point before, and at the very latest when the vacuum was applied. And that also applies to Part F. Part E is the failure to monitor fetal status. During that, I'm going to allow G to go because obviously that is one of the red flags, if you will, that Crawford points out, and Orange to a lesser extent, as indicating an earlier C-section would have been the appropriate course here. Subparagraph F again involves the tracings regarding the heart rate. It's written broadly enough that it can proceed at this point.
Which letter was that, Your Honor? I'm sorry.
H can proceed.
H.
Yeah,
Thank
H. I may have misspoke, but
That's
I
fine.
did
Thank
say
you,
that.
sir.
It's a lot of letters here to go through.
Right.
It looks like I involves the oxygen rate, and I did not find either doc faulting the specific application of oxygen. I think there was some discussion in there as to whether the oxygen was continuous enough, but at the end of the day, the oxygen, of course, mom's oxygen did remain appropriate, and of course, because the doc Caldwell ruled out a hypoxic injury, that the oxygen wouldn't have been a causative factor. So I may be dismissed at this point. J is a progression of labor, and that can continue as a claim. K, document time and delivery of fetal head, neck, shoulders, and the rest of the body. I believe that was debunked during the deposition, and Crawford acknowledged that that was actually documented, so K can be dismissed. L is failed to provide oxygenation. That's the oxygenation claim again. As I said, neither expert faulted directly the lack of oxygenation with the outcome in this case. So L can be dismissed. M is the failure to deliver the baby quickly in the face of fetal distress. That again goes to those red flags. And I think looked at broadly, that's the core of plaintiff's claim here, is that a C-section should have been done earlier. So M can remain. N involves a failure to stop Miss Evans from pushing and deliver that 10 liters of oxygen to the rebreather. Neither expert, suggested that a pause in pushing, other than the obvious pause required to perform a C-section, would have been helpful in terms of oxygenation here. So N may be dismissed. O, permitted constant pushing for 31 minutes without a break to let the baby recuperate. Again, I didn't see either expert testimony that there should have been a break there. So O may be dismissed. P is the larger, broader claim, failure to respond timely in the presence of fetal distress. That can remain. Q applied the constant downward traction, which caused what I'm going to say is the brachial plexus injury. Here, Crawford did testify that he believed that application of traction combined with the presence of the shoulder dystocia was the cause of the brachial plexus injury. So I believe that Q can stay. R says failure to perform a C-section in the presence of prolonged fetal distress and prevent fetal hypoxia, reduce the risks of shoulder dystocia. The only one that can stay there is to reduce the risk of shoulder dystocia, based on the baby size and mom's hip size, like Dr. Cardwell said. However, there wasn't, as I said earlier, sufficient evidence of prolonged fetal distress or, a concern by the doctor about fetal hypoxia there. That either of those were there. So I think really what R would read is failure to timely perform a C-section in the presence, C-section to reduce the risk of shoulder dystocia, and then accompanying brachicardial injury I talked about earlier. Subsection S is the inappropriate application of a delivery vacuum. I think, again, it stems more broadly from plaintiff's complaint that, hey, doc, you shouldn't have applied traction or a vacuum. You should have done a C-section. I think there are facts to argue about what would have taken longer and what would have been better for baby in this case. However, I think S has to survive because the doctor did say that, the application of the vacuum ultimately certainly caused the brachicardial injury. T is, a critique of the delivery in terms of using a different technique rather than the one that was applied, which was McRoberts. The baby could have been delivered in another manner, to perhaps avoid the, or get around the shoulder dystocia that was occurring. I'm going to allow that one to stay, even though I didn't see a huge amount of. I did see, at least one of the experts talked about some of those alternative corkscrew maneuvers or whatever they call them that can be used to deliver baby rather than applying suction in the presence of the shoulder dystocia. U is failure to deliver the baby without trauma, atraumatic delivery. I believe that the standard of care doesn't require atraumatic delivery, but rather to avoid trauma-causing injury. So I think that one actually goes a little too broad. I am going to dismiss U. Having observed those 9 births, I don't think there's anything like a trauma-free delivery. There's some trauma inherent in the process. It's injuries that we're trying to prevent per the standard of care. V says failure to deliver without excessive force, excessive traction, or excessive rotation. I think the traction applied, which is obviously the vacuum, is the one that survives there. So it's failed to deliver without excessive traction, excessive force and rotation not being supported by either expert in this case. W is a failure to properly perform McRoberts maneuver. However, both experts did, other than the fact that they didn't think you should have been going down the road of Roberts maneuver in the first place. They would have called the C-section. However, they don't fault the way that McRoberts maneuver was done. So I'm going to eliminate the um, uh, improper Roberts maneuver and dismiss W. Um, Likewise, X, neither expert testified about the necessity or benefits of an episiotomy. It doesn't appear that among the many issues that they did take issue with, that was one of them. I'll dismiss X. Of course, Y is the failure to timely perform a C-section. That's the core of what's both experts say should have been done here. So Y can remain. Z is excessive, and I'm just going to leave that to excessive traction in this case because that involves, of course, the application of the vacuum and the injury, the brachicardial injury suffered. AA is iatrogenic lateral traction. I think that's the vacuum. Is that what that's referring to, Mr. Dibb?
Yes, sir. Yes, sir.
Okay. Double A can stay because I think Caldwell does say pretty clearly that the vacuum and the traction thereafter did ultimately result in this brachicardial injury in his estimation. And that also applies to BB, which faults downward lateral traction. BB may remain. CC is just a broader statement of that and the excessive forces being applied to the vacuum. That may remain. DD, injuries to peripheral nerves, of course, I guess that is the brachial practices. So a DD may remain as a fact question. EE goes directly to the hypoxic injury there, at least the first portion of it, and that then has to be reduced to failure to safely affect the delivery of the infant without causing peripheral neurologic injury or other trauma, but there is no hypoxic uh, uh, injury here. So asphyxia, which neither expert said occurred, and cortical injury. Cortical injury is a brain injury, correct, Mr. Dibb?
Yes, sir.
Yeah, I think cortical injury from umbilical cord compression and impeded inspiration, those both have to go out of that paragraph, but I'll keep the peripheral neurological injury because that's the brachicardial injury implied. FF, failure to properly intervene and disimpact the shoulder. That is by a rotation of the baby. I'll allow that to remain. They do fault broadly that treatment of dystocia, although I heard them both say pretty clearly rather than doing, additional rotational techniques, what they believe should have been done there would have been a C-section. GG says failure to be prepared for the potential shoulder dystocia and cognizant of the various procedures shown to be effective for delivering the impacted shoulders. There is no question that shoulder dystocia occurred here. Thus, I'll allow GG to remain. Although, again, I both experts say this should have been a quick C-section rather than a bunch of other shoulder maneuvers. Likewise, HH talks about that shoulder dystocia and a failure to as quickly respond to that perhaps as the doctors thought should have been done. II is failure to supprin nursing anesthesia to provide staff to the room to provide assistance. Really what I think they're saying here is, not that there was insufficient staffing, but rather that, the crux of this claim is that failure to perform a C-section. So II can be dismissed. I didn't hear either doc fault the amount of staffing. It's just simply the speed of getting her into the room for a C-section. JJ is instructing Miss Evans not to push. Preparations would be made, presumably there, for the C-section, and maneuvers were taken to reposition the baby. Well, it's kind of a contradictory here because there were maneuvers to reposition the baby. That is to the vet can use that to move baby through the delivery process. So, however, obviously, if there was a decision to do a C-section, then they would have stopped pushing at that point. So I'll allow JJ to proceed as a question of fact. KK, excessive neck rotation, head and neck traction. I believe the sole is not the neck rotation here, but is head and neck traction, as testified by both experts, causing the brachial plexus. So I'll eliminate neck rotation from that claim, but otherwise let KK proceed. LL failed to position Miss Evans with her buttocks flush with the edge of the bed. Optimal access, I didn't hear either expert fault that in their deposition testimony, and thus I'm going to eliminate LL, the positioning of mom. Likewise, MM, neither expert said an episiotomy would have materially changed the outcome here. So MM can be dismissed. NN, failure to drain the bladder. I believe at least one of the experts said, I don't really think that was at the end of the day an issue either. Thus, NN can be dismissed. OO is the increasing traction, which may remain. PP involves the failure to release the impacted shoulder with the dystocia. I guess the argument would be perhaps had that been done instead of the vacuum. But again, these aren't very supported. They are more or less secondary to doc saying, no, I would think I would have done a C-section there. However, I'll let PP proceed because it does involve the response to dystocia. Likewise, QQ can proceed, and RR suggesting, perhaps the whatever metting cold glue maneuver would have been used as an alternative here. And likewise, SS can proceed because it talks about the response to dystocia. TT talks about the gentle traction alone as inadequate because of the dystocia and failure to do the alternative maneuvers. I will allow TT to proceed for the time being. UU has failed to recognize the, pre-birth warning risk factors for shoulder dystocia. I will allow that to proceed. VV is also failure to recognize the risk factors. As regards specifically the shoulder dystocia, and I believe that can proceed. WW, again, pregnancy at risk for shoulder dystocia because of those complications, and essentially saying there should have been a C-section. I'll allow WW to proceed. XX likewise says a timely C-section should have been performed and could have avoided the dystocia. I think that is, again, the core of what's Crawford saying there. I'll allow XX to proceed to trial. And YY says failure to effect safe delivery before injury. That's kind of a broad. However, as such, it may remain as one of the claims. And ZZ again reiterates those risk factors for dystocia. AA is other violations of the recognized existing standards of care uncovered during discovery. It doesn't appear that there are any new ones out there, so I will dismiss AAA as no new breaches, have come up during discovery, at least as briefed by the parties. So that will be my ruling on the partial motion for summary. At this time, I'd like to move to Dr. Crawford.
And just to be clear on the record, Your Honor, I think a couple times you referred to Dr. Cardwell as Dr. Crawford as you were reading your rulings there.
Yeah.
So can we
That
just
all should
clarify?
have been Cardwell. That's entirely my brain enabled to differentiate between the two. So,
Yeah.
yes, those would have all been Cardwell.
Okay.
All right, let's talk about Crawford. And it's a two-part motion. First you say, well, not really qualified. And I think Mr. Dibb agrees with you. She's not qualified to talk about the standard of care, um, either by her training and experience, that is under the Daubert standard, or, under the Michigan medical malpractice statute, where, none of the treating physicians here are neonatologists. Um, so you're saying she's not qualified uh, at all to offer testimony, Mr. Ashner, or just on the standard of care pursuant to the Daubert and the malpractice statute?
Our motion says at all, but also the standard of care, specifically because as we alluded to earlier, she indicated, or she kind of indicated that the C-section should have gone way earlier because of hypoxia, which is what she relies on as her opinion that there was a brain injury here. So
Now,
obviously
Mr.
with
Dibb also pointed me to some points because she said she did a record review, and I think that in there, Mr. Dibb said, well, yeah, Judge, she also looked at these records, and I think at least I think I tabbed something in here where it says, essentially there was trauma at the time of birth, and it points to the, at least the shoulder issue, and those things writ broadly as trauma, not limited to hypoxia. And she says, well, in some cases of traumatic birth, there can be what she describes as these micro injuries. Um, and I don't know that it would be necessarily limited to a hypoxic injury. It could be um, obviously there's the brachicardial injury, not a brain injury, but rather a peripheral nerve. And then, that I think she's implying that perhaps there are other injuries that could have occurred during a traumatic birth, not limited to, and I had to look up the hypotonic uh, cerebral palsy, kind of um, a newer or different variation of cerebral palsy. Are you saying that I mean, obviously she can't say, I think that the doctors caused the hypoxic injury, by their malpractice. She's not the one tabbed to do that. What she's doing is she's starting, perhaps after the delivery and saying these traumas all added up to the symptoms I saw in my review of the entirety of the case.
um, well, Your Honor, I don't know what vague traumas she's referring to because she admitted the hematomas that were caused by the vacuum were simply existed between the skull and the scalp. So those had nothing to do with her internal brain injury. As well as the brachial plexus injury, there was no testimony as to how that might have caused her to develop a brain injury or developmental delays. There was no literature provided. In fact, the exhibits that were marked during her deposition were never provided by counsel. There's been no literature provided to support these opinions. So this is just her saying vaguely, yeah, there was trauma, therefore there was a brain injury, in the same way that she said, oh, the baby was fussy and irritable, therefore she probably had hypoxia.
Yeah. Let me go here because I think the specific one I was looking at is it is Exhibit B to plaintiff's response. It's a Metro record regarding the baby here. And boy, it looks like it's dated 5/5/2013. Admission discharged in MMHH nursery. Continued, it looks like it is not maybe the entirety of the record that I have. However, I was supplied a couple pages here, and I'm referring 323 identifies a precipitating event of, some respiratory distress, shoulder dystocia, fetal tachycardia. Of course, I don't know who made this record. And then flipping to page 330, again describing the nursery course and discussing respiratory distress, hypoglycemia, sepsis, which doesn't appear to be an issue here, head trauma, and left plexus palsy, which I would anticipate refers to the brachial plexus injury. She points to those, or at least Mr. Dibb does in his briefing, and I assume those are among the records that she reviewed. And she says, well, from that I can extrapolate to this hypotonic cerebral palsy. Why can't she, perform a record review like that and say, in my professional opinion, these more likely than not would have resulted in the symptoms I observed later in life?
Number one, Your Honor, because number one, she did not review any of the patient's neurology records, which she admitted in her deposition, which very clearly indicate that no neurologist who specializes in brain function ever even considered that she had a birth trauma or a traumatic brain injury. They all said it was genetic. She did nothing to rule out any
Do we
other.
have neurologists that are going to testify, or do we have experts on both sides?
Absolutely, yes.
That's kind of what I thought. But I mean,
yeah.
at the end of the day, it would go to weight, right? Crawford can give her opinion as a neonatologist. The neurologist, arguably, the bottom line expert in such matters, and then unfortunately the jury is going to have to decide a battle of the experts here. But why can't Crawford take the stand and say her piece?
Well, it's a methodology issue, Your Honor, and an evidentiary issue. So number one, I agree that's what this says, but none of this says that she had an injury, and all of her imaging after this did not show an injury that would show with these things, hypoglycemia, respiratory distress, head trauma, etc., had caused any brain injury. Secondly, there's
I think you're saying these are symptoms, but there's no diagnosis of the injury. Obviously, there's symptoms identified in the nursery care.
Exactly. And Dr. Crawford's methodology was, oh, these are documented, therefore they caused this brain injury. However, she ignored the fact that there's ample evidence that this could just be genetic, given that Eliana's siblings have the same issues and don't have a birth trauma. She had genetic testing that showed abnormalities in her genes. And her mom admitted that she had like 6 concussions before she was like 6 years old or 7 years old. So there's nothing to indicate that those things, either the genetics or the concussions, didn't cause these delays that plaintiff's claiming of. And Dr. Crawford took no effort to distinguish those various types of causes for which there actually is evidence. There is no evidence to show that these symptoms or these documented conditions caused any injury or issue to Eliana Evans. And additionally, Michigan law requires that methodology for an expert. Like if several causal factors are just as likely, you have to show some effort to rule them out, not just pontificate with no methodology or no basis. Like I said, there's been no medical literature provided. There's no imaging saying, oh yeah, because of this hypoglycemia or this respiratory distress, there's been a brain injury. It is just Crawford's opinion without establishing all the links of that causal chain that are required under Michigan law as far as for methodology and factual basis. It's a giant leap between here's what the symptoms are that are documented, and here's a brain injury that caused Eliana's delays when she's never even been diagnosed with a brain injury. It's pure speculation whether she even has a brain injury.
Sure. No, and I think that right, that's a a legitimate, and I guess the question is right, how do we present that to the jury if we're going to get to a fact question? And really, with my ruling on hypoxia and no brain injury, per the experts at birth, then we move to these way less specific and subjective evaluations. Let me give Mr. Dibb a chance to weigh in as to why that is sufficient factual basis for Crawford to reach what are some pretty she sounds pretty assured in her conclusions that she can trace this all back. Um, mm, why shouldn't I find, I guess the flip side of my question to Mr. Anderson is why shouldn't I find she's overly speculative or guessing as she reaches that opinion, and it wouldn't be appropriate for the jury? That's to you, Mr. Dibb.
Yes, sir. Well, let me first address this issue that counsel raises regarding her methodology. She used a reliable methodology. She did not speculate. So let's go down the list of things that she reviewed. Well, first she reviewed the pleadings of the case, the affidavits of merit. Those are legal documents, okay? But she also reviewed thoroughly and carefully the labor and delivery records, the neonatal records, the pediatric records, the therapy records, school records, neuropsych evaluations, the deposition testimony in the case, MRI images, photographs, and a day in the life. So, and she, by the way, also personally met with Eliana on a Zoom conference with her and her mother extensively and conducted an independent medical evaluation of the child. And contrary to what counsel said, she did, in fact, perform an independent medical literature review, and she applied those neonatal perinatal principles to the facts. So contrary to what counsel was saying, her methodology is sound, it's scientific, and it's based on her training, education, credentials, and experience, together with her review of the medical literature. Now, defendants may disagree with her opinion, which I would expect that they would. They're arguing things that can be brought up on cross-examination, but that does not make Dr. Crawford's opinions inadmissible. And under Daubert and MRE 702, the court screens unreliable methodology, but it does not decide the ultimate truth of competing medical causation theories. So in this case, excuse me, let me emphasize that at the start that she's not being offered as an OB-GYN standard of care expert. Everybody agrees to that, but she is board certified in neonatal and perinatal medicine in addition to pediatrics. And what is neonatology? Neonatology is that specialty that that addresses birth trauma, respiratory distress, hypoxic injury, neonatal encephalopathy, hypoglycemia, and long-term neonatal outcomes from neurologic complications. That's her area, that's her specialty, and she can testify with authority on those various areas. Now, counsel is arguing, well, there's no evidence of brain injury here, but that would misstate the record. The record establishes first that there was respiratory distress at birth. The record establishes that she required resuscitation and oxygen support, that she suffered fetal tachycardia and shoulder dystocia, that she had a subgaglial injury and hematomas from the vacuum delivery. Those are injuries to the head, and that she suffered a brachial plexus and Erb's palsy. She also developed hypotonia, developmental delay, cognitive impairment, cerebral palsy signs and symptoms. So what Dr. Crawford is doing is using her expertise and connecting those injuries to the events that occurred during labor and delivery. And by the way, the fact that she described the child as fussy and irritable at birth it sounds pedestrian, but a baby who is found to be fussy and irritable, those are medical descriptions of a baby who is in fact suffering from the effects of hypoxia or fetal distress. So those, while they appear to be common lay terms, fussy and irritable, they do have significant medical definitions. And that was the context in which Dr. Crawford was using those terms. So I think Dr. Crawford is eminently qualified to talk about all the issues in this case. And while defendants dispute her opinions, that's why we have a lawsuit. That's why we have a case. And they can march their experts in and disagree with Dr. Caldwell. There I go again. Dr. Crawford, not Cardwell, excuse me. They can disagree with Dr. Cardwell, but that doesn't disqualify her from allowing the jury to decide what the case is about. The jury should be allowed to decide causation. And causation in this case depends on the interaction between the fetal monitoring, the prolonged labor, the maternal risk factors that we've talked about, the vacuum delivery, the shoulder dystocia, the respiratory distress, her condition at birth, hypoglycemia, and they may find hypoxia and the long-term neurologic deficits are related to these events at or around the time of birth. These are not simple factual issues. These are exactly the kind of technical medical issues where expert testimony assists the trier of fact under the Michigan Rules of Evidence. I can address and respond to defendants' alternate causes arguments if the court would like.
No, I view those as
okay.
primarily going to weight.
Okay. All right,
I
sir.
agree with your counter argument there that those primarily go to the weight of Crawford's testimony. The primary thing that I did want to explore, is can we get from Crawford's review of the records and the, information contained therein after the baby is born in this case through present and find that she has applied adequate scientific methodology to that analysis. And I think that's really the crux, at least as I see it, of this motion. And I think you responded to that by
yes, I
pointing
did.
me,
I hope so.
to the records.
Thank you, Your Honor.
Good. No, well, before the court, as I said, is a motion to exclude expert testimony, specifically in this case from Dr. Carolyn Crawford. She is a neonatologist, and her role in the case as an expert witness has been essentially a record review. She has acknowledged that she's not qualified to opine on decisions made before and during delivery, in that she purely picks up her opinions based on the baby's condition after delivery, and of course those can include conditions that arose during the delivery, as were pointed out in the records, and say, thus I can trace those conditions forward and offer an opinion that the child's current condition is a result of the injuries present after the baby was born, without offering, the breach of duty and uh, malpractice opinion that she's unqualified to talk about, in terms of what occurred during the birth here. And of course, there's also, some division in that, typically the OBGYNs are primarily charged with the welfare of mom. She's their patient after all. And, secondarily, of course, the safe delivery of the baby, and the neonatologist or someone examining baby is going to have that relationship more directly with the baby. So there is a somewhat of a fine distinction there in the terms of the roles of the different physicians. And importantly here, I don't think there's any dispute that Dr. Crawford is qualified as a pediatric neonatologist. She does have sufficient experience, training, and professional licensure to offer expert testimony. The main beef taken up by defendant here with Dr. Crawford is, Judge, if you take into account the fact that there isn't objective evidence, that is, radiological studies of the brain, MRI, etc., indicating brain injury here, that she simply makes too much of a leap from baby's condition in the hospital after birth to state that some of the conditions that the now teenaged child contends with on a day-to-day basis. And further, of course, that she doesn't account for multiple other potential causes of those which may be more likely than those that Dr. Crawford testifies to. However, I disagree that she doesn't have a sufficient basis for her methodology here. As I pointed out during the oral argument, there are at least a couple of pages of medical record, and of course, it's not required to have imaging studies, and ideally, I guess we would have objective evidence of every step of the way, but doctors don't always have the luxury of clear imagery and objective studies to draw their conclusions from. And here she was able to read the records and determine that the child, at least when in the nursery, had identified a precipitating events of a shoulder dystocia and fetal tachycardia, that being somewhat interrupted or reduced variable heart rate during delivery. And then second, I do also note that there are notes that baby is blue or pale from delivery, although, there's also an APGAR score in there, some notes on respiration on page 323 of the record that was supplied by Plaintiff as Exhibit B in his brief. And then second, page 330, under nursery course, does report that there was respiratory distress, hypoglycemia, sepsis, which is not an issue in this case, head trauma, pointed out, here as this application of the vacuum, although again, there's not very much testimony out there that particular head trauma, that is the subdural hematoma caused by the vacuum device, had any long-lasting effects. I take it as a read that head trauma, could have been a factor in, what Dr. Crawford's conclusions are here. In other words, it's not the entirety of what she based her conclusions on, but it's just a part of that. And then, of course, the other part is the left plexus palsy. I think that referring probably to the brachial plexus injury, which everyone agrees occurs here following the application of a vacuum. Notably, I'll note that here there was another exhibit produced by Plaintiff, Exhibit C, which is a later life review of the child when she's 12 years, 5 months old. This is by a pediatric neurology or neuropsych, Dr. Johnson, PhD, at Metro Hospital, or I'm sorry, Cardwell Health, Helen DeVos Children's Hospital, where she notes on page 5 and that Eliana has a very complex medical history, and says that it includes hypotonic cerebral palsy in the context of a complicated perinatal period. And there she cites left brachial plexus injury and resuscitation with lack of oxygen for approximately 30 seconds as being that trauma that the child experienced. So in other words, Dr. Crawford in this case is looking at the situation as she should from a totality of the records that she reviewed and saying, well, these other professionals in their respective fields have noted symptoms and their potential link to the child's current condition. Therefore, I think that her expertise in neonatology could assist the jury in forming conclusions as to potential causes that she can argue are the more likely than not standard required for a favorable verdict by the jury. And I'm sure that experts on the other side will argue that that other causes are more likely than not. But that, at the end of the day, is a decision for the jury to weigh as to the weight of the evidence. It's not a basis to exclude Dr. Crawford as an expert in this case because she does base her findings on what a reasonable neonatologist reviewing a case would do. That is a records review, and that records review does contain adequate support for the matters that she opines upon later. And of course, I'm not saying that that they are the only support, or she couldn't have found more support or reviewed different expertise, but nonetheless, they're not so far afield that she couldn't make the leap. And I will note there, there was a new term there, this hypotonic cerebral palsy, which was supplied, I think it's Exhibit C here, an article from a professional journal regarding, kind of the diagnosis of cerebral palsy and identifying, and I'm on, somewhere in here. Looks like this is page 10 of 36, and this is Exhibit C to the plaintiff's brief, that individuals with pure hypotonia as the cause of motor disability following non-progressive disturbance to the fetal or developing brain may be given a CP diagnosis by some practitioners. Well, here we have a neuropsychologist saying that there is a hypotonic CP diagnosis, and one of the potential causes of that would be following a non-progressive disturbance to the fetal brain. Well, obviously, there could have been a disturbance to the fetal brain. I tie it somewhat to the diagnosis of adult head injury and, head trauma, in that recalling back when I was a happy, violent high school and middle school football player. In order to have a concussion, I think you actually had to have a crack somewhere in your skull that your brain would be exposed. And I carried that forward into the Marine Corps, where I wore a helmet for a good solid 8 to 10 years as a combat platoon leader. And can't even imagine the number of traumas I absorbed through that helmet. So I've often reflected on how smart I might have been had I not received all those various, though I never, officially was concussed or knocked unconscious by any of those things. I do recall seeing stars quite a bit and experiencing quite a bit of lesser than trauma. And I do think that the literature now reflects the fact that, unsurprisingly, many small traumas to the head can, or some degree of small traumas to the head can have a negative effect on you later in life. I wish I'd have learned that information sooner, and for that same reason, I haven't been too sad when my own sons have discontinued playing football for various reasons along different points in their career. I'm hopeful they can avoid that and be smarter than I am at the end of the day. So, but I do think that information about head trauma is progressing, and I think it's essentially what's happening here in the neonatal kind of analysis that Dr. Crawford performed. So, with that being my sidelight for the day, I think I've ruled on at least the motions that are before the court today. Mr. Anderson, can you do an order that reflects everything I ruled on, even though one of them was negative to you? I think it's a pretty straightforward one.
Yeah, and just for clarification, Your Honor, I might need the transcript beforehand, so it might take a minute to get an order.
Well,
but
I'd rather get it
Tyler,
right than
you and
get
I
it wrong and be back in front of me 10 times for it.
Sure.
What's our trial date on this?
We don't have one yet, Your
Okay,
Honor.
well, that helps.
Yeah, and quickly with respect to the Crawford motion, the ruling regarding hypoxia still stands, correct? From
Yes,
the other
that's right.
motion?
Yep,
Yeah, so
that's
there's no
right.
hypoxia issue here.
Correct. No hypoxic injury. Now, the respiratory thing, I think that's probably a separate, and Dr. Crawford can explain that in some way that's, explicable to us as to how that might perhaps equal the micro trauma. But right, no hypoxia during delivery. That stands.
Okay,
but
thank
you
you.
you are denying the Crawford motion.
That's correct.
Okay.
Yep. And Lisa won't be happy, but she'll be able to produce a transcript.
Yeah, thank you, Your Honor. And
If
Lisa,
right.
thank you, Lisa.
If you want, afterwards, we can go over it together and see if we can't agree on the subparagraph rulings. I think that's what you're concerned about.
Yeah, and I think I have most of them.
I took copious notes. If you want, you and I could probably work that out without ordering a transcript, but up to you. But if you think a
Okay.
transcript would be a better, more
Well,
accurate, obviously it would. So,
Yeah, I can tell you that I think it's very 99.9% likely we'll order a transcript regardless, but I'll do an order and send it to you and we can
okay.
figure it out from there.
All right, real good.
So Lisa, just putting you on notice that we are
Okay.
probably going to order a transcript, so you can do it
Okay.
at your leisure.
Okay, just email me when and if you want it, okay?
Okay, thank you so much.
Thanks.
If the
Judge, thank
smoke
you.
persists in Michigan, Lisa, you're going to be caught inside anyway. So, I mean, what else do you
Yeah.
have to do? But
That's
I have
right.
nothing better to do, right?
yeah, I'm sure.
Judge, I want to thank you very much for the extraordinary time you gave us and obviously the exceptional amount of time you devoted in reading the briefs and the exhibits. Thank you very much.
My pleasure. I didn't quite pull an all-nighter, but it was close. We're trying to sort through everything here, but it was extremely well briefed. I appreciate it, Johns.
Thank you, sir.
Thank you, Your Honor.
We're free to leave.
Yeah.
Yeah.